Morning.
Morning.
Good morning.
Good morning.
Okay, I'm just gonna run through the calendar really quick, figure out who I have here, and what we need to actually get accomplished today. First position is Citibank versus Brooke Sellers. Do I have anyone here on behalf of Citibank? Do I have anyone here on behalf of Brooke Sellers? Okay, second position is Citibank versus Jamal McMillan. Do I have anyone here on behalf of Citibank? Do I have anyone here on behalf of Jamal McMillan?
I'm here.
Hi, Mr. McMillan.
Hi, how are you?
I'm going to wait a bit to see if someone appears on behalf of Citibank, though in frankness, I'm not sure I expect anyone to appear. But if you can just sit tight and be muted, I will see if anyone appears on their behalf, okay?
Yes, ma'am.
Thank you. Stony Point Homeowners Association versus Dion Foy. Do I have anyone here on behalf of Stony Point?
Your Honor, Brittany Brock here on behalf of the plaintiff.
Hi, Ms.
And I
Brock.
believe I see Ms. Foy on.
Okay, I do see Ms. Foy. Ms. Foy, are you here?
Yes, I'm here.
Okay, if you can hang on just 1 second.
Okay.
Sorry about that brief interruption. Okay, and so I have both parties here. I will come back to that one in just a few minutes. Have you, Ms. Brock, had a chance to speak to Ms. Pinkett Foy?
I believe there's been some, we've had a settlement negotiation. As of yesterday, we had discussed a forbearance, or excuse me, a consent order. And I believe I sent one to her, but I don't believe it's been returned or signed. So we may need a
I have
moment
not I haven't
to
received anything.
discuss. Okay, it may have sent it to the wrong email address that I had for you.
Okay, well, the reason I ask the question is oftentimes when I have parties in this procedural posture for a hearing, sometimes what I'll do is ask, do you think it would be helpful if I placed y'all in a breakout room and y'all had a chance to speak directly? Ms. Brock?
I believe so, yes, Your Honor.
Ms. Foy?
I agree.
Okay, excellent. Ms. Freehoff, can you please create a breakout room and have Ms. Brock and Ms. Pinkett Foy placed into that breakout room? Okay, next position is Christopher and Creighton Hoffman versus Alluring Africa. Do I have anyone here on behalf of the Hoffmans?
Yes, good morning, Your Honor. Michael Kohler for the Hoffmans.
Okay, and I think I understand that I see somebody identified as being associated with Alluring Africa.
That's correct, Your Honor. My name is Sunit Sangrajka. I am the CEO of Alluring Africa.
Okay.
And I do not have a counsel today because the initial service of this particular this lawsuit was improperly filed, and I didn't receive notice of their intention to file for a motion for default judgment until day before yesterday. So I was actually supposed to be on board a flight today to Canada, which I actually postponed until later so that I could attend this hearing, to let you know and to ask if we can request a continuance so that we may retain counsel in Georgia.
Okay, I understand that, sir. I apologize, sir. Can you tell me how to pronounce your last name so that I can say it correctly?
Oh, sure. It's Sangrajka. It's
Sangrajka.
Yes.
You've got it spelled for me on the screen so I can see it. Thank you.
Okay. Oh, you're welcome.
So, Mr. Kohler, I'm going to walk through a few things with you guys here in just a few minutes on this issue. So if y'all will just sit tight for me for a few minutes, I'll come back to both you and Mr. Sangrajka.
Thank you, Your Honor.
Thank you. The Addison at Cascade versus Nunn Enterprises. Do I have anyone here on behalf of the Addison at Cascade? Do I have anyone here on behalf of Nunn Enterprises?
Yes, Patrice Nunn, yes.
Okay. Thank you. If you'll just sit tight, I'm waiting to see if anybody else appears, that sort of thing. So thank you for letting me know you're here. Next position is American Express versus Charles Day. Do I have anyone here on behalf of American Express?
Waiting for the plaintiff.
Oh, Ms. Drayton? Okay. And do I have anyone here on behalf of Charles Day? Ms. Drayton, had your firm had any, I mean, I know this is a default matter, and so frequently there will not have been a whole lot of contact with the defendant in the case. Have you had any contact with them or had any expectation that they might appear today?
No, we don't, Your Honor. We did file the motion for default, and I called the clerk's office. They said it takes maybe 24 to 48 hours before you'll have the opportunity to see it on the docket. So we're just awaiting. I checked this morning. It's still.
I did receive it, actually just before this hearing. I don't know that it's actually been docketed, but Mr. Freehoff made me aware that it had been filed, and so I am aware of it. What I'll probably do is I'm going to wait just a little bit longer to see if anyone's going to appear, although again, I don't really expect it. I'm going to go back through my calendar, and then I'll still will be expecting, calling on you to work through whatever the default is today. Okay.
Thank you.
Thank you, Mr. Drayton. And then Monarch Holdings versus something on Crumley Place. I believe I just received a consent order with a quiet title on that one. I see Ms. Keeley here. Anybody else here that was here on that matter?
Leon Van Gelderen?
Yes, sir. Am I correct that a consent order was reached and submitted to me on the quiet title for the whole action, Mr. Van Gelderen?
No, it was a proposed final judgment.
I'm sorry, to clarify, but it was a consent one that was with the parties' agreement and the parties that haven't defaulted's agreement. Is that correct?
No, what happened was when we filed a motion for summary judgment, we realized that Fulton County had not answered, and we entered into a consent motion and order with Fulton County, allowing them to answer so that we would not be taking a default as to Fulton County. We still have a motion for summary judgment and a motion for default judgment as to the entire case. And I've sent Mr. Freehoff a final order.
I have seen that final order. I think I reviewed the final order. Everything appeared to be accurate. I didn't have any concerns about it. I think maybe I just wasn't clear on what the procedural posture of the case was in terms of the background that you just outlined.
Your Honor, I did receive it as well, and I reviewed it, and the county has no objection to the proposed order.
Mr. Van Gelderen, so is the final order, would that be a final order as to all outstanding issues in the case?
Yes, the default would only be as to the owner of the property that never answered, and that we served them through the Secretary of State.
Okay. And Ms. Keeley, the Fulton County, you said, has no objection to the entry of that order, and the actual property owner is in default. Is that right?
Yes, that's my understanding.
Okay. Well, the order that you submitted, Mr. Van Gelderen, as I said, it looked to be in order. And so I don't have any problem going ahead and entering that, given that the other entity is in default. The owner, I'm sorry, is in default, and that the county isn't objecting in terms of the interests that are being asserted. Did you need anything else from me, Mr. Van Gelderen?
No, can I be excused?
Yes, sir. Thank you, Mr. Van Gelderen. Ms. Keeley, you both may be excused.
Thank you, Judge. Have a good weekend.
You too.
Thanks.
Okay, Citibank. Anyone here on behalf of Citibank? Okay. Mr. McMillan, I'm going to wait about 2 more minutes. And then I will let you know what I'm going to do regarding the fact that no one has appeared on behalf of Citibank in your case. Okay?
Yes, ma'am.
Thank you, sir. Stony Point, they're in a breakout room. So I'm going to come back, Mr. Kohler. I'm going to come back to you and Mr. Sangrajka. Okay.
Yes, Your Honor.
So let me let you know a few things, both
Okay.
of you. Number one, I did receive the request for a continuance. I don't necessarily have an objection strongly to that, although I'll hear from Mr. Kohler about his position. The primary thing I need to let you know, Mr. Sangrajka, is that technically you're not allowed to represent Alluring Africa, right? Because
Yes.
you're not an attorney.
Right.
And so there's not really a motion for continuance in front of me.
Okay.
And the things that I have seen that you've submitted to my office in terms of your expressed concern about the nature of the service, and those other issues, and I think I saw something about an assertion of an arbitration provision in whatever agreement
Yes.
is alleged to exist. Those are all things I would expect to be asserted in any sort of filing, but at this point, none of those things are in front of me. So I just want to make sure you understand procedurally the posture of the case.
No, I do understand. I unfortunately I didn't have an opportunity, a reasonable amount of time to retain counsel in Georgia. I do have, our attorney that we use here in Florida, but he's not licensed, so he's actually trying to help me secure representation in Georgia.
Okay, thank you, Mr. Kohler. What are your thoughts, sir?
Good morning, Your Honor. Again, Michael Kohler with Miller Morton. We object to any continuance. This is not a surprise to Alluring Africa. This dispute's been going on since the summer of last year. We got involved, notified Alluring Africa that suit would be imminent unless they followed through with their promise that they were going to refund the Hoffmans their money. They never responded to my letter, which was sent to their business address, which was sent to their email addresses. The sheriff's deputy down in Florida served them at their business address. And the default notice was sent to the same address that service was perfected in, which is also their business address. So none of this is just another delay tactic on behalf of the defendant. I never received, to the extent they have an attorney, I never received any communications from their attorney about this. And as your staff counsel, Mr. Freehoff, told the Alluring Africa that if they needed a continuance, they needed to get an attorney and they needed to file something with the court. They did not accept that invitation to do so. And it's completely improper for him to make representations on behalf of the company. He can't represent the company. He can't represent the company's interests. And so we prefer to move forward today. There's no basis for, I'm not going to get into the merits of these purported defenses, but I will say this, those defenses can be raised through a Rule 60 motion if they want to try to attack any judgment that's entered, but everything else is not properly before the court. And so our request, we had the Hoffmans on the call and we're ready to move forward with marshaling evidence to show the court how much damages is due in this case.
Okay. So Mr. Sangrajka,
Yes.
what Mr. Kohler says is accurate. And there are, I mean, if you ultimately retain counsel on behalf of Alluring Africa, your counsel would be, they could give you guidance on what steps, might be necessary to take or that you might choose to undertake. But the record evidence that I have in front of me, and this has nothing to do with the merits of the case, are that service was made on the registered address. I understand that you dispute that, but there is a return of service in the record that indicates that a law enforcement agency made service on the registered address on March the 24th, and that proof of that service was filed on March the 27th. Now, again, I understand that you dispute service because I think what I saw, again, it's not properly before the court, but I understand that you assert that there was a different unit that was served and that unit is where your mother, who is not competent and or legally authorized to accept that service on your behalf. I understand all those things.
Okay.
But I'm just telling you what my record shows, right? My record shows that service was made on the registered address by a law enforcement officer who's authorized to serve process. That proof of that service was filed on March the 27th, which means that Alluring Africa's answer would be due on April the 28th. And that as of under Georgia law, Alluring Africa became in default immediately on that day.
Okay.
And that there is a period of time under Georgia law where Alluring Africa can open default as a matter of right, which is 15 days. And that time period has passed as of May the 13th.
Okay.
And so all the record evidence that I have indicates that Alluring Africa is in default under Georgia law. And the only issue is one, what that means under Georgia law. Well, it also means that under Florida law. But what it means is that the well-pleaded factual allegations of the complaint are deemed to be admitted because they were never disputed. And in this particular instance, what Mr. Kohler has asked the court to do is to consider the issue of damages because some aspect of the damages that are sought by the Hoffmans is what we call unliquidated, which means that it wasn't a finite amount that was set by a contract or agreed account amount or something like that. Mr. Kohler, is this an issue where the contract damage is liquidated, but the attorney's fees are unliquidated, or is the entire amount unliquidated?
Yeah, that's a good question, Your Honor. I believe the contract amount is liquidated because they paid for services that they didn't get. They were promised a refund, so they're supposed to get their money back. So that's a finite amount. Obviously, our attorney's fees is probably the unliquidated portion of what we put up today.
Okay. And the reason I ask is because my recollection of reviewing in preparation for today's hearing, my recollection of reviewing the pleading is that there is a finite specific dollar amount asserted as contract damages, and that the amount, and if that is accurate and what you are seeking other than attorney's fees or interest, I don't know what the contract provides or statutorily, but if the specific amount of damages other than attorney's fees and interest that you're seeking is the amount that is listed in the complaint, then I believe that amount is liquidated, and you would be entitled to a judgment on that amount by default.
Yeah.
And then the only evidence the court would need to hear would be the claimed evidence of attorney's fees that were expended to recover that amount. Mr. Sangrajka,
Yes.
what would happen now is that I would, as I have just said, I based on the record evidence I have in front of me, it appears that the plaintiffs are entitled to a default judgment against Alluring Africa.
Okay.
At minimum in the amount of the liquidated amount, I think it was $40-something thousand for the alleged travel costs that were paid, which again is deemed admitted. And then now what would happen is I would hear evidence from Mr. Kohler, however he wishes to present it, regarding the amount of any alleged attorney's fees that are raised. And so that's what we're going to do now in terms of proceeding. Do you, again, I understand that you dispute this. You feel like you've been caught without notice. I understand those things. I'm not trying to be unreasonable, but I do want to make sure that you understand that position, even if you disagree with it.
No, I understand what you're saying. What my question is, this is what you're proposing is a default judgment. After this, is there another procedure to final judgment or something like that? Or, do I still have an opportunity to retain counsel in Georgia?
Your Honor, may I object? He's seeking legal advice from the bench, which is improper.
Yes. Mr. Kohler, I appreciate that. So, Mr. Sangrajka, I can't give you legal advice. It's not proper. What I was going to tell you, though, is the same thing I said a moment ago, and I think Mr. Kohler even said it. If you retain counsel, your counsel can give you advice about what steps you might take to attempt to protect your interests. All I can tell you now is that where we are now is procedurally proper. And so we're going to go ahead and proceed and allow the Hoffmans to provide evidence of the unliquidated portion of their damages. Mr. Kohler, how would you like to do that, sir?
Your Honor, what I'd like to do, I agree the 48,000 and some change is liquidated, and I think that's deemed admitted. We've also asked for prejudgment interest, and I'd like to just put in a little bit of evidence of when that interest started running.
Okay.
And with that, and then I'll get into the attorney's fees if the court doesn't mind.
That's fine. The reason I asked about how you're planning to do that, if you're talking about interest, that's probably something you're going to need to call a witness for. As in terms of your attorney's fees, you can state in your place, or you can have your client testify regarding those issues.
Yep. Attorney's fees, I'll just state in my place. I will like to introduce Mr. Hoffman. He's on the
Yes, sir.
call right now. And Mr.
Okay.
Hoffman, you could raise your right hand. And
Good morning, Judge.
Mr. Hoffman, good morning. Can you please raise your right hand, sir? Do you swear that the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Kohler.
thank you, Mr. Hoffman. Mr. Hoffman, please introduce yourself to the court.
Christopher Hoffman, and I'm here with my wife, Creighton Hoffman.
Okay. And Mr. Hoffman, at one point in time, Alluring Africa agreed to refund your money that you spent for a vacation in Africa. Is that right?
That's correct.
Okay. And I'm going to put up on the screen an email here. I want you to see if you let me know if I'm able to share my screen, if you see my screen there.
I do not see your screen, so I don't think you're sharing. You're free to do so, but I don't think you are until now.
Okay.
There, go ahead.
Mr. Hoffman, do you see my screen there?
I do.
Can you identify that for the court, please?
Yes, that's an email that was sent from Alluring Africa to my wife, Creighton Hoffman, at her email address stating your refund is in process.
Okay. And do you know what the date is on that?
The date is July 1st, 2024.
Okay. All right. And Your Honor, the point of showing that is when the proposed order we submitted to the court, we ran the interest back to that date. That's the date that they promised to refund the money. And it obviously hasn't happened. Otherwise, we wouldn't be here today. So when we calculated the date under Georgia law, it runs at 7%. So we just added up the days since then to calculate interest.
Thank you. So I have a copy of your order, Mr. Kohler. Can you tell me though, that date is not in your proposed order, and I'd like for it to be. Can you tell me what that date is?
It is July 1, 2024. And I think it may have been, I think in the motion that we.
Oh, it was. It's in your motion. It just wasn't in the proposed order that I was reading.
I got you. The amount of interest owed through today would be $3,059.72.
Yes, that's what I have in the proposed order.
Okay, good. My math's right. So, Your Honor, we've established through the default the principal amount of $48,493.16. The prejudgment interest should start accruing from July 1 of 2024. That amount totals $3,059.72. We've also asked for our attorney's fees in this case. Under 13-611, we've argued that the Alluring Africa has been stubborn, litigious, caused unnecessary trouble and expense. They promised to do the right thing, which in this case was to refund the Hoffmans. They memorialized that by way of email, and they didn't follow through on their promise. And the Hoffmans reached out to them multiple times. And when they were stonewalled, the Hoffmans reached out to me. I've represented the Hoffmans for a long period of time. I also represent Mr. Hoffman's company. So our relationship goes back a long time. I trust him, and I'm sure I hope that he trusts us. When I got this, I tasked one of my colleagues and associate, Raquel McGee, to kind of look at this, find out what happened, when it happened. And in November of last year, Raquel, after doing her investigation, sent out a demand letter to Alluring Africa. As I stated earlier, that demand wasn't responded to. It was met with silence. Miss McGee, she ended up going on maternity leave, and another colleague of mine at the office, Peter Kritikos, he stepped in. He's also an associate. He stepped in, drafted up the complaint, got that filed, retained coordinated with the sheriff's office down in Florida and got them served. And so my time that I have in this case, and I'm a partner at Miller Martin. I've been a partner. I've been practicing law for almost 25 years. I'm the head of our litigation group. I oversee about 45 attorneys. I'm responsible for setting our rates, and part of that process is knowing what the rates are in the Atlanta market, making sure our rates are competitive. And so I set our rates in the associates who work at my firm, including the paralegals. And the amount of time that I have, not including the time I have over the last couple of days, I have about a little less than 3 hours of time on this. I delegated as much as I could to keep the costs down to Ms. McGee and to Peter. And they've got about 23 hours of time in the case, and paralegal time is a little less than 3 hours. Each month, as custom, I send invoices to the Hoffmans for the work we perform. Those invoices that we've billed total $13,674.37. I've got copies of those invoices that I'm happy to tender into the court's record.
Okay. Can you tell me, Mr. Kohler, what is, you told me the amount of hours that had been expended by the associates versus you. I apologize if you said it and I did not hear, but can you tell me a little bit about your normal rate and the normal rates that are charged by your associates?
Yeah. So in 2024, my hourly rate was $590. We adjust those rates every year. And so in 2025, my hourly rate is $630. Ms. McGee's hourly rate, she only performed work in 2024, and her hourly rate in 2024 was $430. And Mr. Kritikos's hourly rate in 2024 was $450, and his hourly rate in 2025 is $480. The paralegal who's been providing support on this, her hourly rate in 2024 was $275, and this year it's $295.
Okay, thank you.
And those rates are competitive with reasonably situated law firms here in Atlanta. And these associates I've worked with a long time. I trust them, and they do a good job, and that's why I asked them to provide support for me on this particular matter. I'm going to share my screen here now. And let me know when you can see that, Your Honor.
I can see it.
Okay. This is the first invoice that we sent out to the Hoffmans. This is when we were engaged in the summer of 2024. It was for $580. And this was kind of the start of the relationship when we first learned about this dispute. The next invoice that was sent was for $1,983.50. And this is Miss McGee performing her investigation to find out what happened and when, and started preparing a demand letter. The next invoice, not a lot of work done in September of 2024. This invoice was for $215. And the Hoffmans, we submit these invoices each month for work performed the prior month, and they pay. There's nothing outstanding on any of these invoices. They've paid them all. Next invoices was for $1,005. And again, this is investigative work and preparing demand letters and starting to prepare the complaint in this case. And the invoice after that was for $3,186. And each month I look at the pre-bills, I look at the invoices to make sure that the work was performed was reasonable and necessary. And if I don't believe those two things are met, I reduce the invoices accordingly. These don't reflect any reductions that were made. These are after any reductions have made. This is the finalizing of the demand letter that happened in November of 2024. And then the next invoice was for $680.76. And this is when Peter got involved after Miss McGee went on her maternity leave. And then in February of 2025, the invoice for $4,218. This is when we're drafting the complaint and getting the complaint filed and getting it ready to be served on the defendant. And then in the next invoice is for $1,114.50. And we tendered these into the court, and we filed these with the clerk's office yesterday. All these are identified as Exhibit D, Part 2. Part
Yeah,
1.
it looks like I did locate them when I was reviewing. They were filed, I think, with a certificate of services document number 7 in my file. And you're right, they're Exhibit D. So.
Yeah, and I think, Judge, Part 1, I performed kind of a high-level summary of these that just identify the date, the invoice, and the invoice amount as a summary.
Okay, I will tell you if there is a Part 2, what I have as Exhibit D is just the summary table document.
Okay.
So it may be if there's a second one that it hasn't arrived yet.
Yeah.
But I'm able to review these documents. I'm familiar with legal billing, and your outline of them is acceptable to me. Although obviously going forward, they should be made part of the record. So
yeah. So yesterday I did a notice of filing of Exhibit D Part 1 and Exhibit D Part 2. So those were submitted, I believe, yesterday afternoon. So those should be in the record, and we moved to tender these into the court's record formally.
Okay, they're admitted. That's fine. And as I said, they'll be part of the record more formally once they're accepted by the clerk.
All right. And the only thing that these do not include, these are the actual invoices that were submitted to the client and paid. They total $13,674.37. We have not billed the Hoffmans for the time we've spent in May. That totals about $2,880. And that's also an estimate for our time to prepare for today and our attendance today. So the total amount of attorney's fees is $16,554.37. And as I said, we believe those are reasonable and they were necessary to deal with this dispute, prepare the complaint, get the complaint filed, get the complaint served, submit the motion for entry of default, and plan to prepare for the hearing today. So we ask that the court award the Hoffmans their attorney's fees related to this dispute.
Okay. Thank you. So I, as I said, I had a chance to review the complaint. I do believe that the primary judgment amount sought by the Hoffmans in the amount of $48,493.16 is a liquidated amount that was admitted in the complaint. I agree with Mr. Kohler that there is a basis for seeking prejudgment interest as of the date when allegedly Alluring Africa agreed to provide a refund, which I believe has been represented to me as July 1st of 2024. So that unliquidated amount of $3,059.72 would be recoverable. And then having reviewed and heard the information from both the Hoffmans and from Mr. Kohler regarding both prejudgment interest and the attorney fees and expenses, it appears to me that the amount of time was reasonable and necessary under the circumstances, and that the hourly rates charged by Mr. Kohler and his associates are reasonable for the business environment and economic environment in which we work here in the city of, in the greater Atlanta metro. So for that reason, I believe that the amount of $16,554.37 that was sought by the Hoffmans for their expended attorney's fees is also reasonable and recoverable. And the underlying finding that's necessary, which was a violation of 13611 is admitted by way of it being a default judgment. And so for that reason, other Mr. Kohler than adding in a brief sentence about the running of prejudgment interest and the entitlement to prejudgment interest from July 1st, I am going to grant the default judgment in favor of the Hoffmans in the total amount of $68,107.25. Mr. Sangrachka, if and when that will be finalized, and if and when you retain counsel, y'all can take whatever steps you would like to. I suspect that order, the judgment that I will enter will be finalized today and likely entered today.
Okay.
Could be as late as tomorrow, but no, tomorrow's Saturday. So it could be as late as Monday, but it will likely be entered today. Mr. Sangrachka, any other questions or anything that you have from me before we adjourn this matter?
No, at this stage, I will be retaining counsel, and
Okay.
we'll see. From what what I've been told, that there could be some grounds for us anyway. But I will speak to our attorney.
Understood. Thank you, Mr. Sangrachka. Mr. Kohler, anything else from you?
Do you need me to submit anything else to the court? Do you need me to massage the proposed order? I sent it in Word format. If there's
No,
any-
I have it in Word format, and I'm happy to edit it myself to make sure that it reflects the order that I want to enter. So I don't need anything else from y'all. I'll finish that order, and it will probably get filed today.
Great. Thank you. And that concludes my business. May the Hoffmans and you kind of be excused.
Yes, thank you all. You all may be excused related to this matter.
Okay, thank you.
Mr. McMillan, thank you for your patience. It will be rewarded in the sense that, as I said, I'd not heard anything from counsel representing Citibank in the matter pending against you. My order to appear for these hearings says that if you fail to appear, we reserve the right to dismiss the matter. Now, to be clear, Mr. McMillan, I don't know anything about the substance of your case. I don't know anything about the time that Citibank might have to try and bring this case back, right? So I can't make any promises or tell you anything like that. I can, however, tell you that this action is going to be dismissed because Citibank has failed to prosecute this action. And so I will be dismissing this case today. Do you have any questions for me, Mr. McMillan?
No, Your Honor. Thank you.
Okay, thank you. Have a good day, sir.
You as well.
Mr. Freehoff, just to be clear, position 1 is also being dismissed without prejudice because of Citibank's absence. And as we discussed earlier, I would also like to note that that Citibank also failed to secure service in both of those cases. Okay. So next up, I see that Ms. Brock and Ms. Pinkett-Foy have returned. Thank you for your patience while I worked through that other matter. And also thank you for your effort to discuss. Any chance that y'all reached any sort of resolution that y'all might be able to share with me? Ms. Brock?
Yes, Your Honor, I believe we have it just about worked out. We may have, there's one more point of contention that I need to get some clarification from my client on. And then we should be able to have this drafted and signed off on in the next few days. And hopefully by Tuesday, we're hoping that we can get a signed order filed and then sent over to Mr. Freehoff.
Okay.
For your review.
Thank you, Ms. Brock. Sorry. Ms. Pinkett-Foy, does that accurately reflect what you understand?
Yes,
Arisen
ma'am.
based on your conversation. Hang on, I'm sorry.
It's a delay.
The joys of Zoom. Sorry about that. My dog decided that she needed to bark. Anyway, Ms. Pinkett-Foy, I could not hear your effort to answer my question. Do you feel like y'all are close to a resolution that you believe just needs to be finalized and can be done so in short order?
Absolutely. And I want to thank Ms. Brock for supporting me and working with me.
Okay, excellent. I'm really glad to hear that. I find frequently, that's why I always offer the opportunity to discuss before we go into the merits of the case, because I find frequently that the principal hasn't had a chance to really talk with the lawyer about what's going on in the case. And so I appreciate Ms. Foy and Ms. Brock both trying to work through those issues today, especially because it got to a resolution. What I will do then is, I'm sure Mr. Freehoff, he may already have communicated that to you, but it is my intention to await that ruling and some sort of proposed order from you guys that's a consent order, assuming that I receive that, in the next week or so, as you've anticipated, then we'll get it signed and on file for you. If I don't, then what we'll do is reach out to you guys and see about setting it back on another calendar, just in case that's what needs to happen. But hopefully we won't need to do that. And I will look for the proposed order by consent that comes from everybody in terms of a resolution. Any other questions for me or anything you need from me, Ms. Pinkett Foy?
Yes, from the court, I do not understand court documentations. I am an educator and I didn't quite know what the Rule 15 meant. Any other wording, it was very premature for me.
Yeah,
So
I can't give you legal advice,
Okay.
but I can tell you that Rule
Okay.
15 is when you're seeking a default judgment in order to protect people that are doing things like serving in the military and other things like that. It's a certificate that when a party is seeking a default, they have to file something saying, we've looked at a registry and other things that we're aware of, and we don't believe that this is the reason this person did not respond.
all right, thank you.
Anything you need from me, Ms. Brock?
No, Your Honor.
Okay, excellent. Well, I thank you again both for speaking and seeing and being able to try and work this out. And I will look forward to a consent order coming early next week, and we'll get that on file for you as soon as we have it. Thank you both.
Thank you.
Okay. The Addison at Cascade versus Nunn. Who do I have here? Ms. Nunn, I still have you.
Yes, Your
Hang
Honor.
on just 1 second. Sorry. Okay. Ms. Nunn.
Yes,
Let's see. Do I have anybody here on behalf of the Addison at Cascade? Okay. Ms. Nunn, technically Nunn Enterprises isn't actually here either, because as you probably heard me explain to another individual who's the principal of a corporate entity, you're not actually legally, unless you're a lawyer. Are you a lawyer?
no, I'm not. He's out of the country, so
Okay.
it's no way.
No, and it doesn't matter because ultimately, as you heard me say to some other people today, the Addison at Cascade, all of my orders when I notice hearings, they say that if you fail to appear, I reserve the right to dismiss the case. And the Addison at Cascade has failed to appear today. And so I'm going to dismiss the case for lack of prosecution. We will enter that order. Now, as you, again, may have heard me say to some other people today, I can't guarantee you that the Addison will not attempt to file some other suit against you. I have no idea I don't know anything about the substance of your case or the timing of any of the issues in your case. All I can tell you today is that because the parties failed to appear, this matter is going to be dismissed for lack of prosecution. And so this case will be closed and will no longer exist unless and until someone files a new case or asks me to reopen this case, and Nunn Enterprises would receive notice of such a request. Do you understand that, Ms. Nunn?
Yes, I do, Your Honor.
Okay. Thank you. You may be excused.
Thank you, Your Honor.
Okay, and then American Express versus Charles Day. Ms. Attorney Drayton, thank you for your patience. I apologize. So I'm going to make it a little bit easier for you, which is to say I've reviewed the docket, right? And so my review of the docket indicates that Charles Day was served on March the 28th. That service was proof of that service was timely filed on April the 2nd. The answer was due on or before April the 28th, and no answer was filed. The final default date would have been May the 13th. Are those the dates that you have as well?
Yes, Your Honor.
Okay. Mr. Freehoff, before I get started with this, did you need something?
I just wanted to ask Ms. Drayton to please submit a proposed order in Microsoft Word format to my email address for your consideration, Your Honor.
Yeah, and I was going to ask her to at the end of the hearing, but thank you. I appreciate that. So beyond that, are the amounts that are sought by Amex, are they fully liquidated or are there attorney's fees as well?
So we are not seeking attorney fees.
Okay.
However, we are seeking court costs. So,
Okay. What are the amount of your court costs if you want to state in your place?
the court cost is going to be $268. $208 is the filing fee, and then $50 is the service fee.
Okay. And then beyond that, the amount that let me make sure I'm correct. The
principal amount we're seeking is $15,894.20.
Okay. If you, Ms. Drayton, will submit to Mr. Freehoff a proposed order in Word format. And if you can do it today, we'll get it on file. I will tell you that one of the reasons I go through the relevant dates is that just to give you a practice tip for when you're in front of me, is I like the beginning paragraph of the default judgment to say service was accomplished on this date, and therefore the answer was due on this date, and they didn't answer. And so that way, 2 years from now, if one of us has reason to go back and look at that order, we're both clear on what happened and why we entered a default judgment without having to go back and look at the docket and do math. Count days and such. So if you can do that for me, and then include the liquidated amount that you are seeking plus those very small amount of court costs, then the court will go ahead and get that order on file for your client as soon as we can. Okay?
All right. Thank you so much, Your Honor.
Thank you for your patience, Ms. Drayton. Have a good day and a good long weekend.
Same to you.
Okay. Hey, Mr. Freehoff, can you stay on for a minute?
I can't, Judge. I don't know who that person was who came on briefly and
I
disappeared.
don't either. And also, why was Mr. Van Gelderen so...
Judge, we are still on YouTube. Would you like me to end that?
Yes. But why was he so abrupt?
Give me 1 sec.
That was the quiet title. In any event, I just wanted to run through these really quick because there were so many of them.